Okay, so let's talk about the midterm exam, which is going to be, this is online on our Canvas page, and not on MindTap. MindTap are all the assignments. So the midterm and the final exam are both going to be on our Canvas page under the test section, or you can also find it on the quiz link over here. So the midterm will be available until Wednesday of finals week. So you don't have to take it right away. It's up there. You can take it when you want to. But a couple of things. Number one, when you take it, you have to finish it in one sitting. You cannot pause and come back and keep going. So there's no time limit on it. You can take as long as you want. I wouldn't take too long, however, because if the computer glitches out on you, it's going to cut it off. So, but there's not really a set time limit. It's set up so that once you take it, you have to finish. You can only take it one time. And when you answer a question and you move on to the next one, I don't think you can go back. I think the setting is once you take a question, it goes to the next question. So just be prepared for that. You can use your notes and everything like that, that's fine. There are 3 types of questions on the midterm. The first are fill-in-the-blank questions, which come out of my course materials, and we'll go over those in just a minute. We have true, false, and we have multiple choice. The midterm is worth 200 points to your class score, which is roughly 20% of your grade. So you should be able to click on it right here on the link. If it's not showing on your Canvas page, please let me know, because there's a setting that I have to click on so it shows up on the home page. If you can't find it on your home page, it should be under the quiz tab no matter what. But it should be showing on your home page right at the beginning. So just click on that to start it. And right there, they take the quiz button, and that will start it. The fill-in-the-blank questions, you type your answers right into Canvas, and then the true, false, you do those first. Those are the first, I think, 9 or 10 questions, I don't remember exactly. And then from there, you go on to true, false, and multiple choice. And it's all right there in one setting. So let's talk about the fill-in-the-blank questions. So all of the fill-in-the-blank questions that I write up, I take out of our course material book. And so just to go through them real quickly here, starting on page 2, categories and classifications of law. So that's a possible question. So the question would be basically list 4 categories or classifications of law, and then anything on this page is a good answer. Civil law, criminal law, procedural law, substantive law, etc. Now, I may also ask true, false, or multiple choice question. So I may ask you a question like, the law says that it's illegal to wear an ugly tie in the city of Monmouth, and that is subject to 1 day in jail. That is a civil law, true or false? It's false, because jail time, right? So if there's a possibility of jail time, that would be a criminal law. So I will have multiple choice and true, false type questions coming out of this as well. So different categories and classifications of law. Oh, by the way, I forgot to say, the midterm will only cover the materials that I've covered in class. The MindTap materials are much more expansive. They cover a lot of different areas that we don't talk about. So the midterm is over the materials in the book here and my lectures in terms of the subject matter. If I haven't talked about it in class on the videos, it won't be covered on the midterm. All right, it might be covered on MindTap, but then that's out of the textbook. Okay, then on the next page, sources of law. So this is pretty much guaranteed 100%. List up to 6 sources of law. And then anything on this page is fine. So U.S. Constitution, federal statutory law, or U.S. Code, either one's a good answer. treaty law, federal administrative regulations or the Code of Federal Regulations, the CFRs, executive orders, I already said treaties, but anything on this page. Now in terms of true, false, multiple choice, I have a number of questions that come off of this page. First would be something like, give you the different laws, maybe these four right here, U.S. Constitution, and I mix up the order. And then I may ask you in a multiple choice question, give you 4 or 5, mix them up, and then you pick which one is in the correct order of authority. Obviously the U.S. Constitution is always on top, right? I also want you to know which branch of government creates each source of law. So legislative branch, executive branch, judicial branch for judge-made law or common law, treaties or by executive branch. So that's why I have the L, the E, and the J over here. I want you to know the purposes of the Constitution, to organize government and to define and reserve rights of the people and the states. I want you to know that common law refers to both English law and nowadays precedents, case law, judge-made law, which we talked about in class. Okay, so next, page 10. The 3 fundamental concepts of the United States that begin with law that begin with the letter S. So we have supremacy, and of course supremacy refers to this idea of higher and lower level of laws, with federal law being supreme over state law under the U.S. Constitution. We have the doctrine of separation of powers, and that is where the legislative branch has the authority to make law, the executive branch to enforce the law, and the judicial branch to interpret the law. And if one branch of government is acting outside that defined authority, that's a violation of the Constitution, violation of separation of powers, we call that. That's where we get the idea of checks and balances. And then we finally have the third, and that is the doctrine of stare decisis, which is a fancy way of saying precedents. That is, higher level court cases like the U.S. Supreme Court will override all lower level courts, and it also stands for the idea that judges should follow previous decisions so that we have consistency in court decisions, apply the law equally for future cases that are similar to previous cases. That gets us to this idea of precedents. So supremacy, separation of powers, stare decisis. Okay, page 19, jurisdiction. Jurisdiction refers to the authority of a court to handle a particular type of case, and this refers to geographical location, personal connections, and the different type of courts. So I want you to be able to list out 4 types of jurisdiction, and they're both on this page and the next page. So we have trial court jurisdiction, original jurisdiction, appellate court jurisdiction, exclusive jurisdiction, concurrent jurisdiction, where 2 or more courts have authority. Next page over, personal jurisdiction, subject matter jurisdiction. Personal jurisdiction refers to the connections with the people involved, the plaintiff and the defendant, and the location of the court. And remember, a connection I'm talking about, you live there, you work there, you do business there. That's where the incident occurred. That's where the contract was signed. Some connection with all of the parties. In rem jurisdiction, which we didn't really talk about too much, that just basically means you own an asset in that location. And that way the court has jurisdiction. And then we have federal jurisdiction. And I do also have multiple choice questions on that. Federal jurisdiction, the 2 different jurisdictions to get you into federal court. Letter A is diversity jurisdiction. Diversity in this context refers to the parties live in 2 different states. They cannot live in the same state if the lawsuit is based on state law. In addition, you have to show that the value of the lawsuit exceeds $75,000. Got to have both of those. That's if it's a state law-based case. If it's a federal law, that's called federal question jurisdiction, and you can go to federal court every time. Regardless if the people live in the same state, it doesn't really matter. Because of federal law is involved, therefore you go to federal court, which makes perfect sense. All right, next one is page 23. And this is where we have the various courts that have something to do with the state of Oregon. So on the top we have the courts that are arising out of the state court system. And what I want you to be able to do is list 4 different courts. And I also want you to know which are the primary trial courts in both the state court system and the federal court. So in the state of Oregon, our primary trial court, I have highlighted there, number 4, is called the Circuit Court. So it's the Circuit Court for the state of Oregon in whatever county you're in. So we're in Polk County, Oregon. And Dallas is the Polk County Circuit Court for the state of Oregon, which is our primary trial court within the state system. At the federal level, the primary trial court is called the Federal District Court for whatever district you're in. We are the federal district for the District of Oregon. We only have 1 district in the state of Oregon. Washington has 2, etc. So I just want you to know, the test question would be, what is the name of the primary trial court in the federal system? And the answer would be the Federal District Court. Okay, page 25. Pretty much 100%, fill in the blank. What are 6 methods of dispute resolution? And anything on this page will work. This would also, litigation is also a method of dispute resolution, of course, so I'll accept that as an answer. So I want you to know, be able to list out 6 of these. And then I also want you to know the first 4, primarily, and that is settlement is the most common way that cases are resolved, through a mutual agreement. Negotiation is direct discussion without a third party in the middle. Mediation is where you have a third party in the middle. They will not make a decision, however. Their job is to facilitate the parties in reaching a settlement and agreement. And we have arbitration, which is similar to having like a private judge. The arbitrator will make a decision like a judge would make in a trial. So I want you to be able to differentiate between mediation and arbitration. And that's real simple. Mediation, no decision will be made by the mediator. In an arbitration, the arbitrator will make a decision. Okay, next page over. Not really a fill in the blank question, but these are the steps in a civil lawsuit. And I want you to know the main steps. And I've highlighted them here: complaint, answer, discovery, trial, verdict, appeal. CAD, TVA. Those are the primary steps in a civil lawsuit. Now, on to the fill in the blank questions. Page 28, we have pleadings. So fill in the blank question would be name 4 types of pleadings. I also want you to know which party in a lawsuit files a particular type of pleading. Complaint is by the plaintiff. Reply is by the plaintiff. The other 3 would be filed by the defendant. And then I also want you to know the basic idea behind a pleading, and that is to provide a factual explanation to the court, allegations of fact, and also a remedy. What outcome are you requesting that the judge provide, or the jury if it's a jury trial? And I want you to know there are 2 basic types of remedies. A remedy at law involves money. So that would be out-of-pocket costs, lost profit, lost wages, medical expense, etc. The other type of remedy is an equitable remedy, and that is a court order of some type. It might be a court order prohibiting contact, a cease and desist order. It could be an injunction prohibiting cutting down of trees. It could be any type of remedy that's not involving money, but it's involving a judge ordering something not involving money. That's called an equitable remedy. You can have both, but you have to specify that in your pleadings to tell the judge what outcome you want, what remedies you're looking for. Next page over, discovery. And on this page, from the fill in the blank standpoint, be able to list 4 types of discovery methods. And I also want you to know a general idea of what is discovery, and that is the process of basically investigating that gives lawyers the ability to find out information about a case, what evidence the other lawyer has, what witnesses, and then the ability to ask them questions through a deposition, to get documents through a request for production or a subpoena, to compel people to come testify at a deposition or a trial, issue a subpoena for that, those kind of things. Interrogatories are written questions. So be able to list 4 types of discovery tools or methods. Okay, next page over, burden of proof. Don't really ask this as a fill-in-the-blank question, but I want you to know the concept. Burden of proof means, number 1, which side has the obligation to prove something. That's the burden. And then what level or how well must you prove your case? How strong is the evidence? The highest form, of course, is in a criminal case, and that is proof beyond a reasonable doubt, which is the highest standard we have. And then in a civil case, it's a much lower standard. It will typically be a preponderance of the evidence standard, which is much lower. It's like 50.1%. And that's what will apply in most civil cases. Okay, moving on to torts. Page 56. And again, we have the intentional torts. And I want you to be able to list out up to 6 of these. So anything on this page and on the next page. Also, I want you to be able to tell me which torts may apply to a fact pattern that I will give you. And again, it may be more than one tort. There may be multiple torts involved. So when you're going through the answer, make sure that you read all of the answers on a multiple choice question. Because what I may ask you, which intentional torts apply, I may give you 5 choices. So maybe it's a battery, and so battery is number 1, so you say letter A, but maybe it's also an assault. And so letter E would be, this is both a battery and an assault. So make sure you read all the answers before you answer the question, because there may be more than one tort involved. And then know kind of the difference between them. I will not make you write out all the elements, okay? You don't need to memorize every single little element of each tort. You don't, like I won't say, what are all the elements of a false imprisonment case to make you write that out. No, I won't do it that way. It'll be more of a generic, Bill locked Ted in a closet overnight. Which tort might that be? Something like that. Okay, then on page 59, negligence. What are the primary 4 elements of a negligence? And that is duty, breach of that duty or violation of the duty that causes an injury. The injury may be personal injury, physical bodily damage, or it may be property damage, lost profits. So injury is some kind of harm that resulted from a breach of duty, and causation. So DBIC, duty, breach, injury, cause. Those are the 4 basic elements. I also want you to perhaps list 1 or 2 defenses to a negligence case: insurance, failure to prove all 4 elements, somebody assumed the risk of an injury, they signed a liability release, there is percentage fault that needs to be apportioned by the jury, that's called comparative negligence. So those are all defenses to negligence. Next page over. What are some of the different types of duties or level of responsibility we have? What are the names? May have you list out those. The standard one being reasonable person test, and then on through the rest of these. And then finally we have what we went over, strict liability on page 63, and what are the 3 areas where strict liability applies in tort law. Now I put here, don't confuse this with constitutional law, strict liability or strict scrutiny, which we haven't really gone into, but you'll see that on the MindTap assignment page when they talk about that. So we're talking about tort law here. So ultra-hazardous activities, explosive dog bites, workers' compensation or employee injuries, product liability or defective product, any of those are good answers. All right, and so again, that's the extent of the material on the midterm. Contract law through the end will be on the final. So once again, the midterm is available now. You can take it whenever you want, up through the Wednesday of finals week. It will be open through then. If for some reason it's not showing up on your Canvas page, please email me and I will fix it for you. Also, if you have an internet outage during the midterm and it cuts it off, email me and I can reset it for you, but only for that circumstance. I can't reset it because you want to take it over again, right? And I can tell. If I reset it, you're going to have to start all over again. It won't start from where you left off. It totally zeroes out your score and you got to start all over. Okay, are there any questions about the midterm? All right, if not, we are going to be done for today and we'll start on contract law next class session.